Hello everyone, this is Tom Fox and I'd like to welcome you to episode 287 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technological firm that helps clients manage risk across 4 key areas, including sales and sales channels, suppliers, customers, and human capital. You can get more information at the Red Flag Group website, which is www.redflaggroup.com. Today I have with me Keith Hennessy and Joel Androphy, who have developed the idea for the first FCPA Mock Trial Institute. It will be a 2-day event held in Houston, Texas on November 16th and 17th, where they break down and put on a mock trial regarding an FCPA compliance fact pattern, and then spend a second day analyzing it. You can register for the event at www.shopaba.org/2016FCP, and of course I'll link to this in the show notes. The episode comes in at just over 28 minutes, and it will be a fascinating discussion of the case. I hope you enjoy it. Thank you.
Very kind introduction. And let me just say for the record that the basis of this mock trial idea was frustration I'd experienced over many years of FCPA practice, that no one ever knew exactly what the law meant because no case had ever been taken to trial, or almost no cases. Our colleague Joel Androphy actually tried one and won one. But American law was designed to be tested and forged in the crucible of a courtroom. And the imprimatur of the court decisions is what sharpens and focuses and injects common sense into the enforcement of the law. And that simply has not happened in the 50-year history of the FCPA. And so we thought it would be fun to take a hypothetical that I designed to be as close as possible in either direction, winnable by either the prosecutor or the defense, and put on a mock trial. And we've received a very kind offer of assistance from Judge Costa of the Fifth Circuit to preside over it. And we have an experienced actual prosecutor as the prosecutor and an experienced actual defense attorney as the defense counsel. And we're going simulated and decide the case. And I don't know how it will come out, but we think it'll be a lot of fun to watch.
So, Joel, you are a partner at Berg & Androphy, and you have the great distinction in the FCPA bar for having gone to trial against the government and successfully defended John O'Shea in an FCPA criminal trial. And you are going to be one of the defense counsel on this, and were one of the people who were instrumental in putting it together. So from your perspective, what do you hope to accomplish?
What we're hoping to accomplish is what we've tried to accomplish for a while, but this is the right venue, is instill within lawyers and companies that they have avenues other than trying to settle a case. These cases can be tried. And in my experience, because the government rarely tries them, they really rarely have trial strategies. And most of the time, they're just working off of settlement issues. And it's sort of, you look at it as the government common law. Judge, we settled the case and these are the issues, and we resolve those in our favor. There's not a whole lot of precedent for the government's positions on prosecution, whether it's foreign official issues or any other substantive or procedural issue, because they haven't tried many. So what we're going to try to do by this mock trial is give corporations an idea of what it's going to take to defend a case, what issues will come up during the course of a trial, so that they can be better prepared to say to the government, we're not going to settle this case, we're going to go to trial.
So you guys have lined up just an absolute A list of lawyers and judges, as you noted, Keith, to preside over the trial. But that's really only the start of the institute part. And I think what takes this idea from simply a mock trial to something that really is outstanding is the second day, which will be the analysis part, where you talk through the facts, the issues from very different perspectives that corporations, defense counsel, and others will need to consider. So perhaps could you talk us through some of the sessions on the institute part and what you hope to at least raise for discussion?
Let's let Joel open with the first panel discussion, which will be the trial lawyers and the judge discussing what strategies worked and what didn't. Because,
yeah. Go ahead.
So few cases have ever been brought to trial in this realm. There's no learning out there on that. There's no standard of the devil made me do it or the victim deserved killing, as there is in every other area of criminal law. Joel?
What we're going to do is discuss our strategy at trial and what we would have done differently and what our potential real-life situation would look like and how we would have handled it. This is to help corporations make informed decisions and not just pay money to resolve these issues. Too many times we hear about a lot of money being spent just to resolve it without a lot of thought going into how you defend these cases. And, once a corporation decides or a bunch of corporations decide to settle it, the government's going to think they're going to settle it all the time, and it's going to become a cash register for the United States. But that doesn't need to happen. I think corporations need to make a stand in the right circumstances and tell the government, put your case on.
And Joel, go ahead, Keith.
Go ahead. Now, I just wanted to add to what Joel said, that that's already become the government's strategy. And that's been going on ever since approximately 2000, that the companies have just rolled over and paid tons and tons of money. And I always found it frustrating when I was working in this area to ask outside counsel, well, what's the law here? And the answer was, well, we're discussing that with the government now. And there was never any more objective standard.
Well, Joel, as I mentioned, you successfully defended John O'Shea, and I heard you speak after that defense with you and Sarah Fraser on the defense team. And one of the things that struck me was, in talking about your defense, was that judges don't view these cases really different than other cases, and therefore defendants and corporate defendants really shouldn't, that you put on your procedural defense and you put on a substantive defense at trial, and judges will listen to what defense counsel lays out for them. And really that was the message that I got from your presentations on O'Shea, that you educated the judge in what you believe the law was, and then you put your facts on at trial and were successful in that.
And it's important, obviously, to challenge the government witnesses. Because, again, in my experience, the government has not been, even though the government operates, around the country in these cases, they haven't had their strategies tested. And the couple of times they've had it, it hasn't worked. And there's too many really good defense lawyers around the country that have their defenses tested all the time and are prepared to handle this. So, for example, with a corporation, if a jury sees that a corporation has done a good compliance program and has done a good job in trying to make sure things worked right, that could bode well for the corporation. If the corporation's had a history of problems, that's a negative. But all that could be tested. And lawyers, what they should do is do sort of mock, like what we're doing today. They should do mock trials before they decide to settle these cases. And what we're doing is sort of like a mock trial prior to a corporation making a decision how it would handle this case. You don't actually have to go to trial before you do a mock trial. Mock trial gives you some sort of feedback about whether your defenses are going to work before a jury. And if it works, great. If it doesn't work, then you can fix it and try it again. But there's a lot of options corporations could take. They're just too amenable to settling with the government, and they're fearful that their shareholders or their investors or the banks will get upset with them if they try to challenge the government. But I think we live in a world today where people are challenging the government on all sorts of issues. So it's part of the norm to make the government prove their case. And again, it's proof beyond a reasonable doubt, which is a very high burden.
But let me add to what Joel just said, that I think one of the different factors about FCPA cases is that all of the events happen abroad, and they happen in a different milieu, in a different culture. And most of the witnesses are non-American citizens. And I think that one of the things that may have inhibited lawyers in deciding to bring these cases to trial is scratching their heads about how would an Asian witness, for example, appear to an American jury or an American judge. And in structuring this thing and casting this thing, I've tried to make that very real. You know, we have at least Americans of different ethnic origin to play these roles, and I'm hoping that that will give a sense of what it would be like to work with a foreign witness, to the lawyers participating and to those watching, because I do think that's an absolute reality in making a decision to take a case like this to trial.
In my experience, they had one thing, Keith, to that. When the government, in my case, brought on some witnesses from Mexico, it was clear that the government had a problem going into Mexico and getting evidence. And we try to make that very clear to the court and to the jury about the fact that there's a lot of evidence out there that we couldn't retrieve because of the restrictions on foreign access, which could, in and of itself, create reasonable doubt.
Well, in real life, the government has tried to go around that by simply demanding that the corporations do the investigation and bring the evidence home from abroad. That's always troubled me a little bit in the context of the letters rogatory procedure. And this mock trial does not explore that. Maybe that's material for another day.
Well, Keith, that leads me to want to ask you about one of the panels that you are moderating. And then it ties in with a second panel, and you're moderating a panel of corporate heads of litigation entitled Options, Government Cooperation, and the Yates Memo. And really, then there's another panel on the Yates Memo. So how does the Yates Memo factor into someone like yourself in your former position where you might have had to, if not make a call on whether to take something to trial, certainly make a recommendation to senior management?
Well, the Yates Memo itself doesn't offer any guidance on this. It just says that the government will, in an appropriate case, treat a corporation leniently if they agree to turn over all of the facts and cooperate in the prosecution of any individuals. And that memo has morphed into, I think, the pilot procedure, as they're calling it now. And the case in our hypothetical I designed that to me was perfect for application of the Yates Memo, because none of the corporate people in Task Corporation, our hypothetical company, had known anything about what was going on with this. And indeed, the sales manager, who's the defendant, didn't really know what was occurring at the gambling evenings in Macau. So it would put me in a position as head of litigation in feeling very conflicted about how enthusiastically do I try to help the government. I mean, obviously, I'm going to give them everything they directly request. Obviously, I'm going to give them access to people and to email files, for example. But at the same time, if I give the government access to the emails, do I need to give the defense access to the emails? Because it may be that there are other emails out there than the ones the government chooses to present as evidence that are, probative of innocence, rather than guilt. And the head of litigation in the corporation here is the only guy who's in a real position to look at this somewhat neutrally. And he's got to live with his international sales force forever after, once this trial is over. And if that sales force sees him or her as having sent one of their own up the river, it's not going to be a good thing for the legal management of the company, because that animosity will transfer to the general counsel and to the compliance officer. So, to me, it's a delicate act, and I don't for sure know how the government would regard my giving copies of any emails I pulled out for the government to the defense counsel also. Maybe that has to be handled through the, criminal discovery proceedings. But it certainly puts me in a delicate position if the defense counsel calls me up and says, can we search the emails? Because my guy thinks he wrote some emails telling this person not to do this.
Keith, if I could change the focus just a moment, one of the things that I think makes this institute unique is you have brought in a panel of not only respected journalists, but journalists who have reported on corporate fraud and litigation around that fraud, and business columnists. What was the reason you asked journalists to be involved, and what do you hope to at least present for discussion on the panel with the journalists?
Well, on the few occasions when I was ever involved in a discussion of, could we risk taking it to trial? The immediate answer was, we can't afford the risk to the stock price of the company, the market cap. And as proof that that was the correct answer, the day the New York Times expose about Walmart hit, Walmart's market cap lost $10 billion. Now, companies have paid hundreds of millions of dollars in penalties, but nobody has yet paid billions of dollars. And nobody has yet paid anything directly out of the pockets of the shareholders. So, I fully understand the logic. But that logic was always based on, what are the newspapers going to say? And, the guys who are journalists, they make their names and fame from talking about fraud and skullduggery and dark deeds. And I can't expect them to change because that's where their market is. But I thought if the people who attend this mock trial got a chance to see how they actually would think about it and discuss it in the context of a very realistic hypothetical, that it might give the lawyers defending companies a chance to know how they could manage relationships with the media better, that it might give the lawyers for an individual defendant ideas for things they might get inserted into the media coverage that they think might help their client. And indeed, it might give the government lawyers ideas for how much more leverage they have in particular cases. Again, to my knowledge, this is not anything that's ever been done before. And I was very grateful when we managed to secure the commitment of the editors and columnists to participate in this thing. And I thought they might just enjoy a day out in the open when they could openly talk about the facts of a particular case, because, of course, they can never do that, on a specific story.
Keith, one of the things that will be touched upon is the role of the corporate secretary. And I was wondering if that's one thing that is really not talked very much about in terms of FCPA compliance, but you've been in certainly been in senior executive roles where the corporate secretary actually has a great responsibility in a wide variety of issues. Could you just touch upon some of the things that you would see a corporate secretary might be called upon to do in a hypothetical or a fact pattern that's like the one you've laid out for us?
Well, the corporate secretary is the plant of the board of directors in management. And he or she is trusted by those directors to make sure they hear everything that they really need to hear. Now, the chairman and the general counsel and the head of litigation and the heads of sales, they all, play their cards close to the vest. But the corporate secretary is the person who has the task of mediating the disclosures to the board and making sure that the board is fully informed as they're required to be by the securities laws and as they're required to be to make good judgments on the direction of the corporation. And so in a situation like this Yates memorandum hypothetical, there's a real question in my mind about, since the company is not at risk, how much would anyone want to tell the directors about the facts of the activity? And I think there'd be a lot of incentives not to say a whole lot to them, just to tell them as much as they would need to know to anticipate what was in the newspapers. But the corporate secretaries would be principal beneficiaries of the newspaper panel because they would get a chance to see on a real life specific case how the media would react to this. And again, that would be part of their job in briefing the directors and scheduling presentations and discussions for the directors about the case. In other words, in a case like this, would you bring in an outside counsel to brief the board of directors on the impact of the case on the company? Or would you let the general counsel do that? I can see going either way. I can see maybe doing no live presentation at all, but just having a good white paper prepared by the outside law firm to brief the board on what was going on. Because the one thing a corporate secretary would not want is for a director to read one of the items in the paper and not have known about it before.
Joel, that brings up a point I wanted to raise with you. From your position as a defense counsel, how would you present to a board of directors or senior management your opinion on whether they should go to trial, recognizing they might not be lawyers, they might not have gone through a major trial before, and understanding that realistically most corporations are going to be risk averse? What arguments could you present to them to help them overcome this aversion and actually take an FCPA case to trial?
I think the best idea would be to put on a mock trial where they could sit and observe and talk to the jurors after. What I mean by a mock trial is we can invite certain people from the public and the community that would hear their case after they've been briefed by jury consultants to go in there and make sure we have 12 objective people listening to the case and the executives listening to the jurors deliberate and talking to them after. And it may inspire them to challenge the case and go to trial, or it may inspire them to try to settle the case. But to me, the lawyers could say all they want about whether they can win or not. No lawyer is going to guarantee anything. But it's best for the executives to see an actual mock trial, which would be de minimis in cost compared to the expense of paying lawyers to go to trial or to try to settle the case.
I can support what Joel is saying with an actual experience. Many years ago, I was managing the defense of a breach of contract claim against the company. And it involved a deal that had been negotiated at very high levels. And the critical witness was the chairman of the board. And he thought the claim was ridiculous. He didn't see any need to spend any time, on preparing for this or any need in doing anything extra for the defense. But we persuaded him through a mock examination and cross-examination in front of a mock jury. And then we let him watch the reaction of the mock jurors to his testimony. And I thought he was going to explode, sitting there watching the screen. But he really became, a super witness. And based on his testimony, we got a motion for directed verdict granted when the case actually went to trial.
Yeah,
and it was all.
I think that's a good point to try to convey. You try to convey to the executives or the board that this could go to trial, but there's a lot of preparation involved in making the executives likable to a jury.
Sure.
The jury that they would be facing in courtroom is not their board of directors. It's 12 objective people that may or may not be, have good feelings about big corporations or any size corporations or the wealth of corporations. So it's important for the executives that are going to testify to see the dynamics and become acclimated and accustomed to that type of venue. This is not a boardroom with be arguing their position, but a courtroom where the consequences are different and the people judging them are different.
Yeah.
Gentlemen, unfortunately, we're at the end of our time, but I was wondering if anyone wanted to follow up with one or both of you directly. Could they email you? And if so, how would they do it?
Well, I put my email on the screen at the start of the program. They're welcome to email me. I'm nominally retired and have some time to dedicate to these things. I'll try to respond to any reasonable question, and I hope people will sign up to watch the show, because I think we've got a good show, and as I said, it's just like professional wrestling. The outcome here is not predetermined, and we just have to see what happens.
Joel?
From my perspective, it's J. Androphy at BA Firm, B as in Berg, A as in Androphy, firm.com, or they can go to our website site, Berg and Androphy, which is BA, bergandrophyfirm.com.
So we've been talking about the first Foreign Corrupt Practices Act Mock Trial Institute. It will be held on November 16th and 17th at Texas Southern University, which is 3100 Cleburne, Thurgood Marshall School of Law here in Houston, Texas. I hope that you will be as excited about this as I am, and I hope that you will sign up to attend. I'm greatly looking forward to it. And gentlemen, I want to thank you again for taking the time to visit with me today.
Thanks, Tom.
Thanks, Tom.
Hello, everyone. This is Tom Fox again, and I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you'd like more information on the first annual FCPA Mock Trial Institute, you can go to the following website, www.shopaba.org/2016FCP, which will give you complete information on the agenda, the participants, and registration information. This FCPA Institute is going to be a really interesting event. If you have any interest in how an FCPA case might get tried, or more importantly, what are the implications of going to trial from the corporate perspective, this is the Institute for you. I hope you can join me in Houston, Texas on November 16th and 17th. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA Compliance Report.